Notice to Assistant New York AG in charge. Former ADA Christopher Schlecht employed at this office is implicated in perjury, filing a false affirmation and conspiracy to conceal malicious prosecution. Unable to proceed to trial against pro se defendant, did invoke CPL 730. Reason: Yagan's omnibus motion for hearing on false statements in answering affirmation and no probable cause. Filed May 30, 2002 and granted. Hearing would reveal false arrests, perjury and collusion, i.e., ADA Christopher Schlecht defends legality of traffic stop by OCSD deputies, citing People v. Engel, 36 New York 2D 413. Onondaga County DA's office prosecuted case with no victims and no crime. CPL 730 invoked after Pro SE was granted in Town of Clay. At unknown date, ADA Schlecht retired from DA. Hired as AG, Utica office. Motion for reconstruction, hearing on illegality of remand on order for temporary observation. Evidence and testimony will confirm order was illegal and deliberate. Onondaga County DA and DeWitt Town Court knowingly usurped due process and perverted procedural requirements under CPL 730. 1 week later, without hearing transferred to CNYPC. Evidence includes records in Onondaga County BHU, Oneida County Supreme Court, and 5 certificates of disposition from Town of Clay and DeWitt Court. Fact: temporary order of observation applies to felony charges NOT misdemeanor. CPL Section 730.40. Dear Judge Siegel, on May 18, 2016 I sent 5-page fax to your chambers. Stated my file was alarmingly sparse. Court records I recall and believe must exist not found, index no. MH02-1025. Statutorily required court orders and related records, CPL 730.40. Motions and affidavits, filed pro se, and recusal by Judge Robert F. Julian. No subpoenas found. Hearing conducted on my motion for hearing on assault and battery by CNYPC inmate Karina Ward on August 16, 2002. No record of my motion for hearing on Dr. Nancy Pena injecting neuroleptics after assault, instead of hospitalization for injuries. Apparently CNYPC protocol to avert civil liability for inmates' assault. Effort to portray unprovoked attack as an altercation. Motion for reconstruction hearing. In the interest of justice, I hereby inform the court I am preparing papers for reconstruction hearing. Interest of justice mandates hearing based on DeWitt Town Court records and certificates of disposition and court history reports. Background: on May 9, 2002, day before jury trial in Town of Clay, James McGraw, my defense attorney, made sudden request to withdraw. Stated his client refused ADA plea offer of dismissal of all charges in 3 cases except failure to keep right. Judge Geiser granted his request. I requested to proceed pro se. ADA Schlecht requested 730 exam, granted by Judge David Gideon. I requested competency hearing. Judge Gideon also granted my request for competency hearing was set for July 9, 2002. Competency hearing is non-waivable, statutorily required by New York State Criminal Procedure Law Section 730.30. Competency exams were contentious. Conducted by Dr. Anthony Slavinsky and Dr. Marilyn Ward. Days later, the DeWitt Town Court clerk said the 730 reports were not submitted yet. She then advised that another hearing has been set for July 2, 2002. Told me, be sure to appear in court. On July 2, 2002, pursuant to the oral notice from Judge David Gideon's court clerk, I appeared at DeWitt Town Court for undisclosed reason. To my shock, Judge David Gideon tells me, I received the 730 reports and have decided to remand you into custody for temporary observation. Fact: temporary order of observation applies to felonies. Fact: final order of observation applies to misdemeanors. Procedures are distinctly different. CPL 730 must be strictly followed. The charges were traffic misdemeanor, driving on a revoked license, which was directly related to the Town of Clay arrest for hit and run that never happened. It was a prank call by 3 kids 11 years old and younger who lived at same apartment complex located in Liverpool, New York. North Star Apartments. I was remanded into custody on CPL 730.40 temporary order of observation. held in Onondaga County Jail on July 2, 2002 for a week. No access to an attorney. On July 9, 2002 I am shackled and transported from Syracuse to CNYPC, also known as Marcy. MHLS is directly implicated and creates advisory position for defendant. Prima facie evidence are the hostile responses from MHLS Director Emmett Crehan. Director MHLS 4th Judicial Department refused TO provide copy of letter I wrote him. On absurd grounds. He asserted the letter I wrote him, after released from CNYPC, was a confidential record. Director Crehan tells me in letter that he will not provide a copy without a court order. MHLS Director Emmett Crehan stated, he will not provide a copy of the letter I wrote him without a court subpoena. New York State Committee on Open Government at my request issued an advisory opinion that said in part, an individual's letter sent to the MHLS Director is not confidential record. Onondaga County DA William Fitzpatrick, Judge David Gideon, Director Emmett Crehan, CNYPC at Marcy, and numerous officials knew the remand into Onondaga County Jail on July 2, 2002, then a week later, in contempt of CPL Article 730 statutorily required competency hearing. Onondaga County ADA Christopher Schlecht, with the cooperation of MHLS, affirmed the 730 reports declaring me incompetent for trial. On July 9, 2002, a competent and innocent defendant was shackled and transported to Marcy on a legal order for temporary observation under Article 730. All knew the remand into custody on July 2, 2002 and commitment into Marcy as incompetent for trial without conducting the scheduled statutorily required competency hearing is of constitutional magnitude. Mandate the court grant quorum nobis motion for reconstruction hearing.